and do it now? Okay, so we'll adjourn now to the work study session, Brown Act training, which you want to introduce, Jerry?
Mr. Simmons, would you care to join us from Young
I think
Money and
everybody got
Core?
the material on this.
I think we sent the material, we sent his bio, he brings with him from our law firm expertise in governance, and in this particular instance, Brown Act training expertise. So we hand it off to you, sir.
Oh, great. Well, wonderful. Thank you for having me down. I was so impressed to see the facility today. I got an opportunity to kind of walk around a little bit and just amazed at all the progress you all have made here. This is, we represent about 2/3 of California's charter schools. So if you don't know this already, you have one of the best facilities of any charter school anywhere in California. So today, it's my pleasure to present to you about the Brown Act and just a little bit about my background. In addition to being a lawyer in the charter school space for the last 15 years or so, prior to that, I worked for State Senator Gary Hart, who authored the Charter Schools Act. And so I actually helped start several hundred charter schools, working with parents and teachers around California before I started practicing law full-time in this space. So I bring with me the experience of somebody who's been part of everything from the very beginning of writing petitions to all the way through all school operations. And the Brown Act is one of the areas that I do a lot of presentations around because it's one of the areas where charter school boards most often run into issues and problems. And it's not that those problems are necessarily terribly serious in the sense that you can typically, you know, the resolution to it is that you would get some training like the one I'm doing now if there's a mistake that's made, or sometimes it's resolved by simply posting an agenda and discussing and meeting again, you know, pursuant to a properly posted agenda. So, but intentional violations of the Brown Act here in California are misdemeanors, and so you certainly want to avoid as board members any sort of intentional violations of the statute that would have the effect of depriving the public of information. And without further ado, I think I'll move on to onto the official slides. So, so today, because violations of this statute, intentional violations, I should say, and emphasize again, are potential misdemeanors, I would encourage you to frame questions to me in a hypothetical sort of way. But I'm happy to answer questions, of course, throughout the presentation. That's why I'm here, is to help make sure that you get the training that you need. And the other thing about this particular presentation, unlike a lot of the others that we do, is that this really is, because it's a legal compliance matter, this is an area where you want to be in consultation with your lawyer and not non-lawyers about your ability to comply. And so while the Charter Schools Association and the Charter Schools Development Center and many other groups are out there to support you with a lot of other aspects of your operations, I encourage you not to consult them about these issues, because if you send them emails or text messages, all those things become evidence that can be used against you in a court of law down the road if there was an actual violation. There we go. So, so today I'm going to talk about it through all these different sort of big picture categories, right? So first I'm going to start with new laws, and that's because the legislature this year actually adopted a bunch of revisions to the Charter Schools Act that tie into the Brown Act that become effective January 1, 2020. So I want to talk about what those laws are going to be because they're so close in time. But until then, you will see that most of the slides pertain to the law as it stands now between now and December 31st. We're going to talk about meetings, notices and agendas, rights of the public at your meetings, closed sessions, when you can have them, how to agendize them, and then we're going to talk a little bit about enforcement mechanisms. Okay? So let's talk first about what's the purpose of the Brown Act. The purpose of the Brown Act is to ensure that members of the public can be informed about items that you're discussing, and also it prescribes some very limited ways in which they can actually participate in your meetings. But keep in mind that these are your board meetings done in public. They are not town hall meetings. And the distinction between the two is that you, members of the board, have the ability to control the amount of time that you spend to a large degree on individual agenda items as well as the meeting as a whole to ensure that you can get through business that you have on your agenda. So while the public does have right to be here, to listen, and to comment on agenda items, still this is your meeting that you're having in public, right? So they don't have an equal right to you to speak, right? So members of the board might have an opportunity to speak longer on agenda items than you would allow a member of the public to do. So, so let me talk a little bit about, I mentioned to you some new laws. Let me kind of frame those new laws for you and give you a sense of what has happened since December 26th of 2018. There have been a whole bunch of events that have taken place. And so I kind of want to get you all on the same page so that we all know kind of where we're going and sort of where we've been coming from. So historically, there was a big debate and a big fight here in California over whether the Brown Act and Conflict of Interest laws and the Public Records Act and other public transparency laws apply to charter schools in the same way that they do to school districts and cities and counties and other government agencies. And so while most charter schools have been complying with the Brown Act and Conflict of Interest laws and the Public Records Act, some were still not in compliance as of December of last year. And they were taking that position because in the Charter Schools Act, there's a provision that says that charter schools are exempt from all laws governing school districts other than those specifically enumerated in the Charter Schools Act. And so they were thinking, they were interpreting that language broadly to mean that they were exempt from all laws governing other public agencies. And so there was a big debate about this. Our office's opinion was that charter schools should comply with all of these laws, and most charter schools were complying. But again, there were some that were not. And so there was this request to the state's attorney general for an opinion on this matter. And that opinion sat pending for several years. It was actually the longest pending request for an attorney general's opinion on the AG's website. And finally, the attorney general answered on December 26th of 2018 that yes, he believed that the Brown Act, the Public Records Act, and the state's conflict of interest laws apply to charter schools today without any need for further legislative action, okay? So, during the same period of time, of course, we had an election for governor going on, among the items that now Governor Newsom was campaigning on was transparency for California's charter schools and compliance with these laws in particular. It was a very interesting sort of issue from my perspective because, you know, we're a huge state. We have a lot of problems. You know, we have wildfires. We have water quality issues. We have all kinds of things going on. And the fact that anyone in a state as large as ours would be campaigning on an issue of charter school transparency tells you that we are on the radar. You know, we as a charter movement are on the radar in a way that we've not been historically in statewide races. So he comes into office with one of his priorities being to sort of end this debate. And he could have done that a couple different ways. He could have waited for litigation to ensue based on the Attorney General's opinion. Attorney General's opinions are entitled to great deference by the courts. So they're not law, but they're entitled to great deference by the courts. And so probably the courts would have ruled in accordance with the AG's opinion, and eventually we would have gotten to that place, right? But he decided no, that he wanted to actually put this into statute. In other words, take the Attorney General's opinion, make it actual law so that it would put this matter to rest once and for all. So his top priority as governor coming into office was Senate Bill 126, which went from a scrap of paper to state law in a record 2.5 weeks. So to give you a sense of what a priority this was for legislative leadership and the governor's office. So SB 126, which we're going to talk about in a minute, was the bill, the vehicle that they used to put all of this into state law and to create some special rules under the Brown Act for charter schools effective January 1 of 2020. In addition to that state level activity, the State Department of Education also has taken the position that all of these laws apply for charter schools authorized by the State Board of Education, either now or in the future. So if you were to ever go there on appeal, for example, that would be a minimum requirement of getting your charter petition approved there. So, you know, what does SB 126 do? I mentioned already that it essentially took the Attorney General's opinion saying that these laws apply, put it into state law, but it went further than the AG's opinion in a couple ways. One is that it made entities that govern or manage charter schools also subject to these laws. So if you had a nonprofit organization, for example, that was in charge of managing the charter school, and that nonprofit was something separate from the charter school itself, right? And so we see sort of two models of charter school governance. Sometimes the charter school is the nonprofit, and the nonprofit is the charter school. That's all those two entities do, right? So they are 100%, the circles 100% overlap, right? In other cases, though, we see circumstances where there's a separate nonprofit and a separate nonprofit that is the charter school, and this nonprofit governs the charter school nonprofit in some way, right? Appoints its board members, removes its board members, takes those sorts of actions. So SB 126 says, well, if you're structured like this over here, then we're going to apply all these same transparency laws to the entity which is appointing and removing board members and things like that, because we're concerned that they have such an influence over the operations of the charter school that we want it to have transparency in addition to the charter school itself. And I mentioned there's some special rules just for you in the Brown Act now. These are actually contained in SB 126, but they interrelate with the Brown Act. So if you have a single charter school, you're required to meet within the boundaries of the county in which the charter school is located. This is a little different than what has happened historically for charter schools that have complied with the Brown Act, because school district lawyers always historically had taken the position that you must locate within the boundaries, have your meetings completely within the boundaries of the school district that authorizes you. So the legislature actually said, no, we're going to override that local interpretation. We're going to step in and give charter school boards the flexibility to meet anywhere within the county in which you are located. For most of our clients, you're going to meet like you are here at the school site, because that's the most convenient place for board members to gather. It's the most convenient place for staff to staff you. It's the most convenient place for parents and students to interact with you. But you do have some flexibility around that, okay? If you're in other circumstances where you have multiple charter schools in the same county, or you grow someday in that respect, right? Then know that there's some special rules that you have to put a two-way teleconference system in place for every single site location that you operate. And so this is something that school districts don't have to do, cities don't have to do. This is a unique rule only for California charter schools under the open meeting law. So school districts, they can just meet in one single location, right? As long as they meet there within the district's boundaries, the public's expected to come to them. They don't have to have a teleconference at every single elementary school that they operate. But if you had multiple sites, you would need to do that. Okay. I've talked about too, this is the circumstance where if you have a governing body other than the charter schools board that actually is responsible for governing the charter school, then again, it has special rules applying to it, which are similar. They kind of mirror those rules. Okay, so let's dive in then. That was sort of the piece about new laws.
One question on that one, Jerry.
Yeah.
Go back one there.
Please, yes.
Does this one, D, apply to us then, or is it two or more charter schools?
So long as you are one charter school board and your only responsibility is managing the one charter school that you operate, then this piece does not apply to you. This will come into play if someday you decided to have more than one charter school that you were governing. This becomes a rule. Now, some charter schools.
Question, Mr. Chair, can I ask a question?
Sure.
So If your governing board is actually a foundation, and that foundation has more than one charter school, how does that apply to us?
Yeah, so if the governing board of the charter school, and it has to be an entity that manages 2 or more charter schools. So if there was a foundation that was actually responsible for managing 2 or more charter schools, then that entity would be subject to all of the provisions here, okay?
But would we be subject to having a microphone or open two-way communication at all the schools that foundation governs?
If you had one foundation and it was responsible for managing multiple schools, yes.
Thank you.
So now we're going to just dive into a little bit about what are meetings, because this is one of the most common things where people just get tripped up because they're not always thinking about meetings in the way that the legislature is. Okay, so meetings happen anytime that a board meets to hear, discuss, deliberate, or take action on an item of school business. Okay, so one of the most common issues that I get from clients is they call me and they say, "Well, Jerry, we didn't take action. I mean, I know we didn't post the agenda like we were supposed to, but we didn't take any action there. We just had a discussion, or we just heard from parents some concerns," something like that, right? So note that the legislature defines a board meeting broadly as any time you meet to hear, discuss, deliberate, or take action. But note also that it's anytime a majority of the members of the board do that, right? So a minority of the board may, in fact, hear, discuss, deliberate, or on items of school business because they're not charged with taking any action on behalf of the board. Now, if that committee, for example, was delegated authority to act on behalf of the charter school, then that committee always needs to post an agenda. And in fact, virtually always, committees will need to post agendas if it's like an official committee established by the board of directors.
Jerry?
Yes.
When posted for a committee, is that posting just like when we have a posting for our regular meeting? That the posting for a regular meeting goes out to every board member. Mm-hmm. For a committee member, for a committee meeting, is that the same definition? The posting has to go out to every member, even though they may not be part of the committee that's meeting.
So that's up to you locally. So you can establish that by board policy one way or the other, whether you want to distribute it to non-committee members of the board.
But it has to be in policy.
But it would have to be in policy. Okay. So you should decide that locally as a board, whether you want to distribute it to everyone or not. Now, every one of those notices, though, keep in mind, is posted online on the school's website. So every member of the board, of course, could have access to that posting online. It also has to be posted physically. Typically, it would be posted here at the school site. So any other member of the board could either see the physical posting or see the internet posting. The extra piece that is in your discretion is, are you going to proactively email a copy to non-committee members? Okay, that's in your discretion.
Would that also apply to committees that are doing investigation of discipline or character or discrimination? Would that apply to all of those committees no matter what?
Almost always. So let's talk about that.
We're talking about board committees, right?
Right, board committees. Board committees. Nearly all committees must comply with the Brown Act unless you can meet all 4 of these bullet points. And when I say comply with the Brown Act, that means meet the posting requirements, meet in open, unless they have a legitimate reason to be in closed session. So let's go over these. First, it has to be advisory only. So remember I mentioned that if you, the board, delegate authority to committee to make a decision on behalf of the full board, then that committee has to post, right? Because they're not just advisory. You've delegated your authority to them. It has to be composed only of board members. So you cannot appoint parents, students, teachers, staff members, or random community members to the committee, or the Brown Act applies to that committee, right? Doesn't mean you can't have a committee with parents on it or community members on it. Sometimes there's really good reasons why you were including stakeholders on a committee. That's fine. Just know that the committee has to comply with the posting requirements, right? Also has to be less than the quorum of the board, right? So again, less than a majority of the board. Because if you had a majority together, what? It would be a board meeting, which should have a board meeting agenda posted for it. And it must not be a standing committee of the board. So standing committees are things like personnel committee, budget committee, audit committee, things like that, which meet on a standing basis, or which are identified in the school's charter. And so I have some clients who have identified certain committees in their charter, and I think if it's identified in your charter, it's a standing committee, and it ought to be posting an agenda.
Excuse
Okay.
me.
So if you can't meet
Question
all
here,
4 of
Jerry.
these points, then it should post, the agenda should be posted for that committee.
If it's identified in our bylaws but not the charter, it's
Same.
a standing committee.
Same, I would say that's a standing committee. If it's identified in any formal governance documents of the board, then I would identify it as a standing committee and post an agenda accordingly.
So we have an audit committee that is designated, it says right in the policy, audit committee. So
Right.
that would be a standing committee.
Right, that's a standing
Now,
committee.
We also have the ability, through our policy, to have other committees. But since that would be something that can come and go, that is not actually, those will not be a standing committee.
Correct,
Okay.
but you just have to keep in mind that you have to meet all 4 of these
Those-
requirements, not just the last one, in order to avoid agenda posting.
Got
So, so this is why I say 99% of the time, you're gonna post an agenda for a committee, because it's often I find very difficult for clients to meet all 4. They might meet 1 or 2 or 3, but usually they get hung up on one of those 4, okay?
These are board-appointed committees that we're
Right,
talking about. Yeah.
Right. So this is not, just to be clear, this is not a committee that staff might convene, like a
Action team
staff
or something,
meeting.
yeah.
Laura can have a meeting of all faculty at the school and talk about curriculum. That's not a committee that needs to post a Brown Act compliant agenda, because she's meeting with her staff in their capacity as employees to discuss, curriculum or something of that nature.
Is time a critical element in that, in meeting the Brown Act requirement that gives the most opportunity for for your community, for the parents, for the interested people that would want to hear about what's going on in this body, in this public meeting?
And what do you mean by time? Explain that question a little more.
No, what I mean by time is convening the meeting, should it not be more targeted toward the audience that you serve and to give them the best opportunity to attend?
Time of day.
Oh, I see, time of
Time
day,
of
those
day.
sorts of things. Got it. That's very helpful clarification. So you may meet anytime you like, but I do think that the point is a good one in the sense that best practice is going to be to try and meet at a time that's convenient for your community to join you. And every community is different. Some of my clients are located in areas where, they have 2 working parents, and that's the norm. And so in a community like that, meeting in the evening is going to be much more convenient for your stakeholders. And for other clients, that's not the case. I have some clients who meet, much earlier in the afternoon or sometimes even in the morning, because that's what they find is convenient for their folks. So it's really up to you. We also have some clients who meet on weekends because that's what's most convenient they find for their stakeholders. So that's entirely up to you as the board to set what time of day and what day of the week you decide is best for you and for your stakeholders to participate with you. So, so I mentioned, that anytime a majority of you are together to talk about school business, we have to post an agenda, right? But there are some very common sorts of things that come up all the time that I want to make sure I cover for you. If you're at some other body's public meeting, a majority of you might be gathered, for example, at the school district board meeting for your charter renewal. Or if you were at the city council meeting because you were applying for some permits or a zoning change or something like that relating to your facilities. a majority of the board might be present, okay? And that's permitted because that other body has agendized that matter, right? So they have put the public on notice that something relating to your school is going to be discussed. And so it shouldn't be a surprise to members of the public that representatives of the school are present, you know, for that conversation. So that's okay, and they've been put on notice. So if the public decides not to show up at the city council meeting, well, that's on them. They had an opportunity to read the city council's agenda and see that your zoning request was on there, okay? Another one is public conferences of general interest. So in our community, there's two major ones a year. There's the CCSA conference in March, and there's the CSDC conference in December. Now that doesn't mean that you couldn't also go to other education conferences, you know, but those are the two that charter schools most commonly have a majority of the board at, right? And that's no problem. You can absolutely be there. You can be in the same workshop. You can listen to the same presentation. But what can't you do? You can't talk about school business while you're there, right? Also, purely social or ceremonial gatherings. This would be things like your graduation ceremony or a promotion ceremony. It might be, you know, you have a fundraiser here at the school, and a majority of you show up for that. Not a problem with you being there, even if all of you were there. Just make sure you don't talk about school business while you're there, right? The place to talk about school business is always in the boardroom pursuant to a noticed agenda.
So let's say, you know, you had 3 or so at you know, like a conference, and you're at a workshop, and all of a sudden you're at lunch and you start talking, you know, hey, this sounds like a great idea, and you start talking about, boy, we should bring this back, maybe start talking policy. Is that a Brown Act violation?
It is if it's a majority of the board.
Sitting there, even though you're talking about something that you saw in a workshop.
It is if it's a majority of the board.
In
That's
our
right.
case, it would have to be 6 people.
Right.
So if you have a majority of the board, then you know
You
that
just
one of you should say, wait, time out, if there's 6 of us or more here,
Somebody take it back.
somebody call the board chair and ask that this be added to the next board
But
agenda.
if
Or
it's
somebody
3 or
call the
4,
board and ask that be
if
added
it's
to the
3 or
next
4
board
or 5, it's okay.
3 or 4 or 5 is fine, okay? Except that, I'm gonna go over in a few minutes a serial meeting rules,
Yeah.
right? So if those 5 later become 6, because one of the 5 of them sends a text message or calls or emails a 6th member about that same topic, then we also have an issue under the serial meeting rules.
So board retreats,
Post agendas,
brainstorming kind of.
Posted
that sort of thing.
agenda.
Posted agenda, okay, thank you.
Majority of board members present, always post an agenda. Yep. So serial meetings that I mentioned are also prohibited is anytime a majority of the members of the board engage in a series of communications outside of a noticed board meeting, right, relating to school business. And note again, this is broadly worded, to discuss, deliberate, or take action. So it's not just voting, it's even just discussions, okay, are problematic. So where this most commonly arises for me as legal counsel is emails. Because just so often, like a constituent, maybe a parent writes in, a community member writes in to the full board, maybe somehow they have all your email addresses, I don't know, are they on the website? Can someone email? So, yeah, so this will happen eventually, right? Somebody will email in with their complaint or their concern, or even something positive, you know, like graduation was really great, I was glad, you know, this year you had lemonade. Whatever, it could be something very positive. It doesn't matter what the subject is, if it's emailed to a majority of you, and then one of you responds and hits reply all, then we have a problem under this, right? Because if you hit reply all, you've now got a discussion outside of a meeting between a majority of you about an item of school business. So make sure if you're ever in a circumstance where a member of the public or the community emails you, or even if Laura were to email you, right? It's okay that initial email to all of you, just make sure you're replying only to the person who sent you the email individually. Don't copy all the rest of the board members on your personal reply.
So even if you said something like, let's add this to the agenda at the next board meeting, would that be a problem?
I think probably if that was all you said, then no, I don't think that's a problem. But
But it's just better.
I'm
to
always
rely on
nervous
the
about
person.
that because oftentimes what I find is that the board member just can't stop and hit a period. They say, they feel the need to add the because I think this is a really great idea, or, which is very innocent, but adding that next phrase after the because makes it a violation because now you're effectively lobbying the board outside of a board meeting, right? And so my suggestion to you is, no, send a separate communication only to the board chair and Laura and say, I'd like to request this be on the next agenda for discussion. And then that way you avoid any sort of argument about that, right?
So how about Facebook?
Facebook, Instagram, any sort of social media thing, if a majority of you are commenting on anything relating to the school, that's a violation, or because it will meet all these tests. So even if it's something positive like your school graduation, make sure a majority of you are not commenting on a parent's Facebook post about that, right? So just be thoughtful about that. I know that that seems like an undue restriction when it's just something nice that someone posted and you want to weigh in, but you know, send some personal congratulations to that parent or child. Don't involve the full board.
One of the things that I'm sure our directors have noticed is when we send out email communications, you don't see all the email addresses because we use the BC function so that you can reply without risking reply all.
Great.
So that's the only reason that we do that.
That's
is
great.
Just to protect everybody.
That's great. Question here?
I know this is drilling down to a level, but if we were to have 6 board members like a Facebook post, would that also,
Yeah, I would do that.
right, just kidding.
I would do
Just
that.
one.
You're the
Oh,
sixth one.
goodness.
Stop.
Check the comments first.
Yeah, I would do
Count how
that.
many you've done.
Yeah, I
Don't
would
do
that.
Facebook.
Yeah,
So,
not a problem.
Don't do email. Don't.
yeah, I wouldn't do any sort of liking. I wouldn't do any sort of, steaming mad face or, any other things like that, and any sort of reaction at all, regardless of whether it's positive or negative. I would just skip it and understand that, the place the public can come see you is here at the board meetings. And the place you can take action in response to their concerns or their positive feedback is here at the board meetings. So these serial meetings can occur one of two ways. We've talked about several of them, but they can occur either in a hub sort of circumstance, and this is your classic email or group text situation where one board member at the center is emailing such that a majority of the members of the board get touched by that one single board member at the center. The other way, though, is, if board member 1 were to call board member 2, and board member 2 texts board member 3, and board member 3 sends an email to board member 4, and, then you get into a situation where ultimately, eventually, 6 board members are involved, you're going to have a violation of this sort of chain scenario. Now, it may be that board member 6 doesn't even know that board members 1 and 2 had a conversation about this. All they know is they got a text or email or phone call from board member 5. What does that tell you as a board member? Always be really cautious because you don't know who else that board member who's calling you has talked to, nor do you know how many other board members board member 4 or 3 may have talked to. Maybe they called other people other than the board member who's calling you. So my best practice tip for you to avoid getting into this sort of problem unintentionally is to say, I really think this conversation should happen at the board meeting, right? Because I don't really know. I don't really know. Now, is it a violation? No, not unless it's a majority of the board, right? But how do you know if it's a majority or not? You don't know all the conversations that may have preceded the conversation that's happening with you. So if you want to have maximum protection, you just make sure that your conversations occur here at the board meeting rather than outside of it.
Does that apply to headmasters, principals, staff, that same scenario where they reach out and even though they blind copy you can't, but they send it out to all of the board members on any issue?
So if it does not apply to staff sending staff reports or other kinds of communications about school operations to the board, whether that's a minority of the board or a majority of the board or all of the board. Staff may always do that, members of the public may do that, parents may do that, students may do that. The issue here is where you've got communications between and among a majority of the members of the board, right? Not communications coming from third parties to the
But that would apply to staff as well. Say there was an investigation and staff sent it out to all the board members.
Staff is permitted to send communications to the full board,
Right,
or a majority of the board, or a minority of the board at their discretion.
right.
What you can't do then is have a member of the board hit forward and comment on that conversation in some way.
Or talk to other board members.
They may if it's less than 6. They just can't get to 6. Limit on one-way communications. So this gets at one special rule that relates to staff, okay? So staff may answer any questions that all of you have. You may call them individually and ask them whatever question you like. So that's the good news, is it's easy for you, very user-friendly for you as a board member. You can ask whatever questions you want. We want you to ask questions. Because if you ask questions, then the work of staff will get better and the school will be great, right? Because your questions are going to prompt, thinking. If something got missed, then the school wants to know that so that, the school can do better, right? But what staff cannot do is they may not communicate the comments or position of any other member or members of the board of directors to you. So, example. One of you might call Laura and say, I have a question about how much we're spending on athletics here at the school in the budget. And I'd like to understand, it looks like it went up about 11% versus last year. That seems like a big jump. I'm just curious, could you help me to understand why? And she'll have an answer for that board member, right? Fine. But what she can't do as part of that reply is to say, I just talked to the board chair yesterday, and I know he shares your concern that that's too big of a growth. That additional add-on comment, she can't add, right? She can answer Kevin's question, she can answer Michelle's question. They might both have called her on 2 different days about the increase in the athletic budget. That's fine. But what she can't do is share with Kevin Michelle's view, or share with Michelle what Kevin's view was. Okay? You get to come into the board meeting.
This applies to staff.
This applies to staff.
Now, a member can share with another member as long as it's less than a
As long as it's less than the majority of the
Right.
board. Correct. Exactly. So teleconference meetings. My general advice is if you can avoid teleconference meetings, you should avoid teleconference meetings because they're an enormous pain. But if you absolutely, hey Dante, how are you doing?
Good to see you. How you been? Good to see you. You've lost weight.
I know Dante from another school. So. Teleconference meetings. If you must have one, and this is anytime you have one or more board members who are calling or videoing in from some other location other than where the board is meeting, then the agenda must be posted at all teleconference locations. So in other words, you'd have an agenda physical posting here at the school, and then you'd have a physical posting where that board member is calling in from. So let's say they're Aunt Dive and they're in Kansas City, right? Well, you'd have to have an agenda posted at the Kansas City Hilton, okay, where they are staying. That's where they're going to be calling in from. And each teleconference location has to be identified in the agenda. So you would list the meeting location here, and you would list the meeting location of the Hilton in Kansas City. All votes have to be taken by roll call, meaning that you now, instead of just being able to say all those in favor and all those opposed, which is pretty quick, you now are going to call each board member by name. And each board member, one by one, has to report their vote, yes, no, or abstain. In my experience, if you have a sort of regular sized agenda, this might extend your meeting time by 45 or 50 minutes. So be thoughtful about, the amount of time that you're going to be asking all your board colleagues to take if you're going to ask to call in by teleconference. It's not just an inconvenience to you, maybe it's you really are taking up a lot of other people's time. Each teleconference location has to be accessible to members of the public for Americans with Disabilities Act Compliance. And so where this comes up is usually people's homes, where they might have stairs that lead to their front door or something like that. If it's not accessible to somebody in a wheelchair, then sorry, that is not an appropriate meeting location. That board member is going to have to find some other location to dial in from. You had a question?
How does the allowance of the teleconference, when one of the meeting places is outside of the county, in which you are chartered? How,
That's okay, because you're going to still have the board meeting within the county. So the board meeting will be here within the county, and this is allowing.
so that's okay.
This is allowing an individual member to be participating from outside at an additional location, not in lieu of the board meeting
What
here
if
in the
a
county.
majority of the board members are outside of the county?
Cannot do that.
Okay, so
Cannot
there
do
is a
that.
prohibition then.
Cannot do
The
that.
majority must
The
be,
majority must be here within the county, yes. Members of the public also must be able to hear and must have the right to address the board directly from each location. Not a huge deal usually in the advent of speakerphones on all of our iPhones, right? But that's something to watch out for. And a quorum of the board must participate from within the charter school's jurisdiction, which gets to your point. Historically, this has meant within the boundaries of the school district, and I would suggest that you continue to do that until January 1, when you know the law changes to be the whole county.
How important is accessibility period to the public or ADA to the meetings of this board?
Yeah, so Americans with Disabilities Act Compliance is required for all of these teleconference locations. So just know that if you have someone requesting a teleconference location, that falls to staff to really make that duty of inquiry to say, can I just verify with you that there's no stairs, there's no other impediments that would prevent someone with a wheelchair from participating. One other note on teleconferences that I always like to talk about, because it's one of those practical tip stories, where people sometimes get sideways and they do something without fully thinking about it. So I have a couple issues that come up here. One is that from time to time, we have people who are, for lack of a better word, stalkers, or, and if you post your home address because you decide to call in from home and now your home address is on that board agenda, just be aware you've now made yourself vulnerable to somebody who might not otherwise have had your home address until you decided to call into the board meeting from home. So just a thoughtful note on that. And then I had one other circumstance where a board had an individual member who was recovering from a hospital stay, and something very controversial ended up coming onto the board meeting agenda. The one meeting that member tried to call in from home. She normally never did. And the parents thought, hey, what would be super fun is her house is actually closer. It's more convenient for us to go there than it is for us to drive on to where the school is. So she had the angry mob in her living room. And of course, this turned into a disaster because there's no staff there to help her usher the people out or to maintain any sense of order, and she has all these people screaming, and you can hear them screaming and chanting into the phone, and so it was just an enormous mess, right? And I don't think they knew that she was recovering from, a serious illness, and so I don't think there was a community-wide understanding or sensitivity of that. So I share those couple stories with you just to say, be thoughtful about whether you really want to be calling in from your home or your place of business, because you might end up with an angry mob in your office and your boss might not be excited about that, or your significant other, kids, etc. may not be excited about having those unfriendly folks in your home. So just something to keep in mind.
What about what about restricting the public to come into the meeting, or having the authorized to come into a public
So
meeting?
we're going to talk about that in just a second. I'll come back to that question. Oh, question here.
Before we move on, just for clarification, are these rules about teleconference meetings referring to when it's a fully virtual meeting, or just anytime you add in teleconference location?
Anytime you add a teleconference location. So if you have one or more board members participating from any place other than here, where the full board is, you're going to trigger all these requirements. By the way, one more thing I should cover before I move on. What do you guys think about somebody's running late for the meeting and they call in and they're like, hey, Laura, I'm on the 5. I'll be there in an hour. Can you just patch me in? What do you think?
No.
No, absolutely not. Because the agenda has to be posted at all the teleconference locations the full posting period in advance. And somewhere on the I-5 is not a location. right? You know, you can't have a circumstance where members of the public can join you in your car. They can't be expected to just parachute in through the sunroof, you know, so. All right. Let's talk about executive compensation, and then I'm going to come back to the question over here that was just posed a minute ago. So, a little bit about this, right? So, the city of Bell, which is down here in LA County, you know, kind of got a little notorious for a while with some things that they were pulling at, you know, meetings at odd hours on odd days, and you know, extreme compensation packages they were awarding to city employees. And so the legislature decided to respond to that in this way by amending the government code to provide that public agencies must discuss executive compensation only at a regularly scheduled meeting of the board of that agency, right? They did that because at a regularly scheduled meeting, maybe there's 2 or 3 extra folks here who would be watching, you know. But at a special meeting at 1 a.m. on Saturday, probably no one from the public is going to make the time to do that, right? So by forcing you to do this one particular thing at a regular meeting, it sort of shines a bright light on it and makes it unlikely that the board would approve $1 million compensation package or something like that that's just completely unjustified. Also, in addition to that contract being approved at the regular meeting, there's a requirement now that prior to final action, the board must orally report a summary of the recommended salary and benefits, okay? So that would include the fringe benefits, so the value of medical, the value of dental, the value of a life insurance policy if you have something like that, the salary itself, anything of value, right, would be reported with that final action happening in open session. So members of the public will know exactly how much your senior executive is making.
That can all be done in the same meeting, though, right?
Same meeting.
Yeah.
And you know, with this I share that there's a kind of, again, another practice tip here, right, for you. Although the law doesn't require you to consider compensation of all employees at the same time, and you certainly could take up at any regular meeting the compensation of your executive director, my suggestion and practice tip is that you try to take up compensation for all employees at the same meeting if you possibly can.
All board employees.
I'm sorry?
All board employees or all employees?
All employees. All employees who report to you. And the reason I suggest this,
Report to who?
who ultimately report.
I mean, in our case.
I mean, they
the
may
board-
report through the administration, but
Okay.
when I say report to you, they're employed by you, right? So ultimately, they're your employees, right? Even if they are an instructional aide who works here 2 days a week, they're still your employee. Now, they may report through Laura and other people on her admin team, but ultimately, you're the ones who are responsible at the end of the day. So for example, if you were to fail to pay payroll taxes for that instructional aide, who's responsible? The board members become personally liable for that expense. So that's why I say they're your employees. They're the employees of the charter school, okay? So why do I suggest taking it up at one time? Well, I'm going to give you an example that I witnessed at Stockton Unified. I was there for a charter petition meeting, and before our item came up was a revision to the compensation for the chief financial officer of the school district. And so the school district board had a prepared statement from their attorney, you know, and they went through it and they made the required announcement. And what you could hear in the room was this audible gasp when the salary number was read out loud. Now, I think what they had failed to appreciate was the politics, that the room was full of people who were making maybe a sixth or a seventh of what that CFO was making. But what I was probably one of the few people in the room who knew, because obviously I work on a lot of, with a lot of schools, I knew that actually that compensation, they were just bringing this person probably to the midpoint of what CFOs of similarly sized districts were making. So I knew that in my head, but they didn't make any effort to sort of say to folks in the public, hey, we have a compensation philosophy here at Stockton Unified that we try to have all employees be at the midpoint, which is in fact what their philosophy is. And so that's how they treat their teachers, that's how they treat their janitor, that's how they treat their senior admin staff. Their philosophy as a board, their board policy, even though it's not in writing anywhere, their board policy has been to treat all employees and try and get them to the midpoint, right? And so they were making this adjustment because they had done a compensation study that showed this person was way low, you know? And so they were bringing this person up to reflect market. But they didn't put all that context around it, and so as a result, it got a really negative reaction from the staff and from the parents and others. And so if you're going to have a conversation about compensation, it's often useful to put those numbers into context so that then everyone understands what your philosophy is, and that you are, in fact, sometimes a percentage isn't the same. You know, 3% for the executive director isn't the same as 3% for an instructional assistant who works twice a week. It's not the same dollar amount, right? But it might be fair. You know, it might be what those positions are entitled to be paid in this community, right? So you just have to think about that in context. And so that's not required by law that you do that for all employees. I just pointed out because it will help you from a public relations perspective.
So in an open meeting, you can still have a closed session, correct?
There is also an opportunity for you to have a closed session, and I'm going to come to that in a minute.
But
about
let's
personnel.
see, I was looking up there, because open meeting where final action will be taken, final action in open session. Are we saying that this whole conversation or discussion, should it be done in open session or in closed session?
So there are components of the conversation which I think would likely precede this final action that would happen in closed. So for example, you might have a circumstance where you are evaluating an employee before you make a compensation decision. I mean, that would be a normal, typical thing that most of my clients would do, is they do an evaluation and decide, are we happy with this person or not? If you're not happy with the person, you're probably not going to then have the subsequent conversation about whether they deserve a 10% raise or not, right? You're going to probably first confront the question, are we happy, generally? Do we feel like this is a good fit and worth continuing this relationship, right? So that piece about, is it a good fit? Is this person performing well? That's an evaluation conversation, and that happens in closed session, okay? And then there's another piece, which is you might, in certain circumstances, be authorizing, you might do this as a full board, but more likely you would authorize the board chair to engage in some sort of negotiation with somebody that you might, for example, be looking to hire. You know, so I sat on a community college board for 6 years, and we came to a place where our president's spot was vacant, and I was chair of the board, and the board said, we're going to authorize you to negotiate up to this dollar amount. Obviously, don't leap automatically to the top, you know, but we'll give you authorization up to this amount as board chair. We want you to make the phone call, have the conversation, see if you can arrive at a number that works for them and for us, and hopefully we end up on the same page. Ultimately, then what would happen, right, is that number and the contract would come in open session. The public would see it, the public would see the contract, the public would know the number. So there's nothing secret about it, right? It's just during the negotiation process, though, here's the circumstance, right? What if you make an offer and somebody says no? Well, you're not going to go to this and be in open session setting a salary for a future employee. What if they say no? What if they say no? That's not enough for me to come. And now you've embarrassed, you know, yourselves and the agency, and you put everyone in a bad place, and now all the other applicants are going to go away because they realize that they're not your first choice, right? So you want to be in a situation where you're only doing this part after you know that you have essentially a handshake, right? It may not be any ink on paper, but you have a handshake that this number, this package works.
So, okay, now that was interviewing for a new employee.
Right.
Okay. In our situation, so I'm just trying to get, you know, I understand the evaluation part. Do we then, as a board, do we authorize, like, our board president to meet with the headmaster kind of get an idea, or do we offer? How do we do it? I guess my question is, how do we do it?
So every board is a little different in this regard. Some boards actually have it be very formal and they authorize the board chair to do those things. In some other organizations, the board chair just has that conversation and brings information to the full board. In some contexts, I've seen executive directors show up at a closed session board meeting and say, this is what I'm asking for. So I've seen all kinds of different scenarios. I've also seen boards say, well, this is what we're offering. And there's no conversation in advance. You know, it's just, this is what we're willing to do based on the compensation study data that we have.
And this still is in closed session, or is this an open session?
So again, your conversation amongst yourselves about negotiating posture is closed.
Okay.
But your final action to approve of the number and the contract are always going to be an open session. So there's nothing.
Compensation study would be enclosed.
So the compensation studies are public documents. And so as a result, we would actually recommend that you consider the compensation study in open session.
Okay.
And there's a reason for that, because if the board considers a compensation study and can document in its minutes that it has done so, then there's a rebuttable presumption under IRS regulations that the compensation that you ultimately approve is reasonable. Okay, now if you get a compensation study and it says the position should pay $150,000 and you decide to offer $1 million, okay, that rebuttable presumption is not going to hold, right? But if the thing says 150 and you say 147, or you say I'm going to make it 151 because there's a lot of extenuating circumstances suggesting it should be something more, you know, a tad bit more, that's where that rebuttable presumption of reasonableness is helpful. So it's good if that data is out there in public. And again, for the same reasons I mentioned earlier, best practice to see that in total as opposed to one position, so that you know, don't put yourself in a PR perspective at that point.
Probably, right? That'd be part of this meeting you're talking about.
Yes, yeah. So typically we would set it up so that you were seeing the compensation study, then you're acting upon, you know, the recommendation.
And also the contract would be there then too.
And the contract would be there as well. Yep. So the public would see the contract, they'd see the numbers, they'd see the compensation study for how you got there.
Does that also include pending legal action where the board could have been at fault, or an employee of the board could have been at fault?
Pending legal action.
Yeah.
So if there is anticipated litigation of any kind, that is not covered under this piece. That will be covered under anticipated litigation, which is a separate reason you can be in closed session. And for those matters, you are permitted to be in closed session to receive advice from legal counsel about how you should respond to either anticipated or existing litigation, okay? And those are closed session matters. They remain closed session matters. The only time when something would ultimately become public out of that is when the board takes final action related to an item of litigation. So for example, you might take final action to authorize a settlement agreement of some sort, right? This is not the negotiation phase, but again, the final settlement document. That would become something that would ultimately be public. And the public would have a right to see what that final number is that you agreed to settle something for. Even though they wouldn't be part of the they wouldn't get to see the back and forth negotiations that ultimately led to that document, just the final thing. So notice and agenda requirements. We've talked a lot about meetings and when you're going to need to post agendas. So the general rule here is the agenda shall be posted properly and shall include that brief description of each item that's on the agenda that would be sufficient for an average member of the public to determine what you're talking about. So when I see client agendas, the most common thing that comes up there is we love acronyms in education. And so we have like ADA. Well, does that mean Americans with Disabilities Act, or does that mean average daily attendance? And so a member of the public could easily be confused by that. So spell things out is my advice, so that you don't have any sort of dispute, that an average member of the public can understand what that item is supposed to be about, right? So that brief description is usually going to be not more than 20 words, and it might be quite a bit less than 20 words. It's just whatever is reasonably necessary to describe it. If you're going to meet in closed session, there is safe harbor language, which is contained in the Brown Act. You cut and paste that onto your agenda and you fill in the blanks, okay? And so the legislature did that because they were tired of disputes about whether the language for closed session was adequate or not, and whether it was adequately descriptive or not. And so they just said, okay, enough. We're gonna come up with language. We're gonna tell all the agencies, just cut and paste. And if you cut and paste the language that we wrote here as part of the Brown Act, then there can be no challenge to your action based on the agenda being vague or something like that, okay? I also recommend that you have a provision on your agenda somewhere where you can request a disability-related accommodation of some kind. Because there's nothing worse than the situation where somebody who's deaf shows up at a meeting and you have no sign language interpreter or something like that, and then you're really in a world of hurt because you just look terrible that you have not figured this out or thought about this in advance, even if they didn't tell you they were coming. Just the fact that you're in that circumstance makes you look terrible that you don't have a solution. And so if you can provide that as part of your agenda, just again, a phone number, a name, here's who to call in advance so that you can prepare. And then a location for inspection of documents distributed to the board. So once staff emails a majority of you, or by US mail sends you, or by FedEx sends you, it doesn't matter the method of communication, once they send a majority of you, any document related to an open session agenda item, that document is open to public inspection during regular business hours, okay? Now, you can choose, to have that be the executive director's office or the secretary at the front desk. You can choose who is going to administer that, but it has to be open to inspection. I rarely have clients have this circumstance occur, but you always want to be prepared. And so what I recommend people do is when that email goes out, put it in a binder. Just put that item in a binder. Just have that as a practice so that you always have a binder with that agenda's backup materials. Again, this only relates to open session items. So if I were to send you an attorney-client privileged communication about a litigation update or something like that, that does not go in the binder because that would breach the privilege, right? So only open session items. So where and when are you going to post these agendas? We talked about on the school's website, okay? And physically posted, and if you're doing a teleconference at each teleconference location. For a regular meeting, 72 hours in advance. For a special meeting, 24 hours in advance. Very, very rarely, you might be able to have an emergency meeting, okay, with 1 hour's notice. The Brown Act only allows that, though, if you have either work stoppage, which is like a strike, right, or you have a crippling natural disaster. A random natural disaster won't do. The legislature says it must be a crippling one. So I've only had, in all these years of practice, one case where any charter school anywhere has qualified for an emergency, and it's where their faculty walked out of the classroom and sat on the public street in front of the school in protest of some working condition issues that they were facing. And that was work stoppage. And so the board was able to call an emergency meeting with an hour's notice, and they held a board meeting to authorize the hiring of substitutes and to take other actions relative to that situation. So emergency meetings, you basically, that'll never happen. I mean, that'll just never happen. You got a crippling natural disaster. Why is it that people don't call meetings? Because everybody knows, right? What's staff going to do? There's a crippling natural disaster. Her job is to make sure employees are safe and kids are safe. If somebody needs medical attention, she's going to dial 911. She's not going to call a board meeting and be like, hey, what do you think I should do? Call 911 or not? She knows. That's her job. So that's not going to be an issue. Okay. One thing I want to make sure you know, as of January 1, 2019, this new rule, that it has to be on the school's homepage, the agenda link, okay? So it can't be buried on the agenda, buried on the website, sorry.
I was just thinking, because you brought up a person that is deaf. What about a blind person? If we have something posted, what do we we have posted for a blind person?
Yeah, so the agenda itself is supposed to be machine readable, okay? And so and that became effective January 1 also this year. And the legislature put that in the statute several years ago and gave a really long ramp up period. I think it was like 5 years or something. So, you know, they really gave agencies a long time to get into compliance with that. So I'm assuming you guys have done that, I don't know, but if you haven't, that's an item, you know, to put on the to-do list if yours is not for some reason. Okay, this is, in fact, the perfect intro to this one. Your agenda has to be retrievable, downloadable, indexable, electronically searchable, platform independent, machine readable, and available to the public free of charge.
Can
And
I
that is in
speak to
fact related to that.
Can I speak to that really
Sure.
quickly? So that text-to-speech apps that you hear all the time, so the text in the agenda can be, with software, you can translate it to speech, so it's read aloud. So that's the machine readable part. And our text is readable, so that works.
Great. So, some exceptions to the notice requirement, that items be on the agenda. There are a couple for genuine, true emergencies, right? And this is not, I want to underscore, not a circumstance where someone just forgot to put something on the agenda, right? It's not intended for that purpose. But if there is a true emergency, then by majority vote of the board, you could determine that an emergency situation exists, and after taking that vote, you could then vote to amend the agenda and add something to the agenda. And you could then, after taking both of those votes, discuss and debate that emergency item. This would be something like, you know, maybe there is a wildfire that's 20 miles away, and you're thinking it's coming in this direction. And we might want to authorize staff to do X or Y or Z to better protect the school's facilities, okay? If the board were in session when that happened, that might be a legitimate emergency item, right? But keep in mind, judges are going to take a dim view of people just declaring an emergency when there's no legitimate threat to public, you know, public safety, public health, you know, the roof's going to collapse, something like that. I mean, it's got to be a truly emergent situation, because you can always call a special meeting with 24 hours notice. So the judge is going to be looking at me saying, well, why the heck did your board not think they could wait 24 hours for this item? Really? They really genuinely couldn't explain to me, Mr. Simmons, why they could not wait 24 hours? You know, and I've got to have a good answer for that if you're going to ever try and use this provision, right? So, so this is very rare. And then there's a second provision that would allow 2/3 of you, or if or a unanimous vote if less than 2/3 of you are present. But there's some need to take immediate action, and that need came to the attention of the entire agency after the agenda was posted. This one usually fails because of bullet point 2. Usually there's at least a secretary or somebody who had some thought that it should have been on the agenda. Maybe some notice was received by someone at the charter school. It doesn't have to be Laura. If anyone at the charter school got the notice, that's good enough to defeat you from being able to add this item. So what do? You call a special meeting with 24 hours notice. You can still deal with it. You just need to give the public 24 hours notice.
I have a question.
Yes.
If after the agenda is posted, the 72-hour regular agenda, the secretary discovers something and we post for a special meeting.
Yes.
Does that special meeting come before or after the regular meeting?
It can be either one, as long as there's 24 hours notice. So that's up to you. And commonly that's how public agencies will catch situations, as long as you've got the 24 hours notice and the board's already going to be together at the same place. Easy to post an agenda for either immediately prior or immediately after the regular meeting to catch items like that. And much better to do that than to try and claim something's an emergency when it's really not. Right? Yeah.
Are there limits to the number of items that can have action taken at a special meeting?
No.
Okay.
The only restriction on special meetings is the one that I talked to you about earlier, that executive compensation can never be discussed there. Okay, that can only be discussed at regular meetings of the board. Rights to enable access and participation. So this slide can be summarized as the public has lots of rights and you have almost none. They have the right to give you oral testimony at a meeting, and that is both on items that are not on the agenda as well as on all of your published agenda items. They have the right to come here, as they will at some point, I predict, if they haven't already, and to say that you're terrible board members, or that staff is terrible, my teacher's horrible, I can't imagine a worse teacher, how could you hire this person? You know, they have the right to say all kinds of mean and nasty things, and I'm sorry, but you signed up to be a public servant. And when you're a public servant, the reality is members of the public will come at some point probably and say that, you know, they're disappointed in you or they're upset at you or whatever. And they will often use colorful language to express themselves. And my best advice for you is sit, take a deep breath, take it in, and don't react. Because if you react, the situation will escalate, you know. And if you just sort of take a deep breath and absorb it, just know that person is sharing from their heart and that they're upset and that, you know, sometimes people just need to vent, right? And that it's actually the best way to handle it sometimes. Now, if somebody is so disruptive that you cannot continue your meeting because they're talking over the board members consistently, constantly, they've brought a set of drums with them and they're banging them loudly such that people can't hear one another, at that point you can call the police, you can clear the room, and then the folks who will be left will be you guys and the media. And so you can do that, but I only advise you to do that in a true circumstance like that, where despite the chair's best efforts, you know, the person won't stop. You know? But, you know, try and give yourself 2 or 3 warnings, and if that doesn't work, the next strategy is I'll tell a board chair, hey, why don't you recess the meeting for 10 minutes? Give people time to cool off. Let everyone go to the restroom, whatever, let everyone cool off, then try and pull the meeting back together, see what happens. If it's still an issue, then call the police. You know, you really have no choice at that point. Members of the public have the right to audio record and broadcast from your meetings. This includes the media and any random member of the public. So they put a tape recorder out. Nowadays, what I see a lot is people recording with their iPhones and doing Facebook Live. And so I'm at meetings all the time for my clients where that happens, and what people are saying is all broadcast and kept forever on the internet. So just be aware of that. There can be no conditions on public attendance, so you can't require someone to have their driver's license or to give their name or their address or anything like that as a condition of coming to the meeting. Now, if they wish to speak, it's perfectly acceptable to have a speaker card and to ask for someone's name and what agenda item they're there to address, so just so the board chair can organize the comments in some logical order and maintain, you know, some semblance of order during the meeting, keep it moving. But if somebody wants to just come and sit in the audience, you know, that's their privilege, and they don't have to give you their name or tell you anything else about who they are. We've talked about the non-discriminatory facilities under Americans with Disabilities Act, and we talked about the fact that copies of your agendas and other public writings have to be available. This last one here is that you must provide 2 times the time for the public testimony for anyone who needs a translator, because English is not their first language. So you just double their speaking time, whatever speaking time you allot to everyone else, they get twice as much. So let's talk now about the permissible closed sessions, and there were a couple questions earlier that hit on this. So there are actually way more than this in the Brown Act, but these 6 are the ones that are applicable to charter schools. So I only have these 6 on the slide for that reason. Number 1 is pending and anticipated litigation. And this is specifically conference with legal counsel regarding one of those 2 things. So if you're in this situation, you should have either a legal opinion from counsel that you're reviewing in closed session telling you it's my advice that XYZ, or legal counsel should be present in person, or legal counsel should be present by phone. You should have one of those 3 things. This is not a time for you all to just discuss amongst yourselves what you think. This is for you to get advice from counsel and to give you an opportunity to ask counsel questions. Okay. So council should be present one of those three ways. Pupil discipline, okay, if you are going to suspend or expel a pupil, and that is going to be an action of the board as opposed to action by the administration or an administrative committee, then you need to have that in closed session because the pupil's right to privacy trumps the public's interest in knowing what's going on or what's leading to that expulsion decision, okay? Personnel here, if you are going to appoint, employ, evaluate, discipline, dismiss, release an employee, any of those are all closed session conversations because the employee's right to privacy, again, trumps the public's right to know what otherwise they have the right to know at your meetings pursuant to the Brown Act.
Where would in our policy, we have the term agent, which I'm considering an agent would be, for example, your law firm. If we wanted to
You want to talk about terminating a law firm or terminating a real estate agent or somebody like that, that's an open session conversation.
That's open session. Okay, thank you.
And it's because those folks are contractors, they're not employees. Employees are entitled to privacy protection, vendors are not. And so, real estate negotiations, okay? This one, there's a common thread here, right? That this one is not about a right to privacy, this is about the taxpayers getting the best bang for their buck, right? Because if you were to have an open session conversation in front of a landlord and you said, hey, we're willing to pay up to $2 a square foot to lease that building from you, well, that became the new floor of your negotiations, right? So the point is to allow you to discuss and to strategize and to tell your agent, yes, you're authorized to go offer X to the other side. And to keep that confidential so the taxpayers get the best bang for their buck, right? Same thing in labor negotiations, same kind of issue there, right? And also, by the way, the pending and anticipated litigation, sometimes people think that's just about the privilege. Well, it's partly about the privilege, but also it's about the taxpayers getting the best bang for the buck. Again, like there's a common thread there, right? Because if you all, if I went to you and I said, hey, I think this case, if you were to go to trial, might cost you $100 grand. I think you're going to lose, and I think this is your damages. You might say, okay, well, you're authorized to settle for up to $100 grand. But what if I go make an offer for $5 grand and somebody takes it? Well, that was a great deal for the taxpayers, right? Because somebody might take far less than you think that their case is worth. And people do that for a lot of reasons. Maybe they want the money now. It's more important for me to have $5,000 before June 30 than it is for me to have $100,000 3 years from now. You know, people have different life circumstances. You don't know what will drive them and the other side in negotiations. So, public security, I hope you never have to use this provision, but this was put in the Brown Act after 9/11 to allow various law enforcement agencies to meet with public agency boards to discuss anticipated or potential terrorist threats against public facilities. So may you never have to utilize that one. Closed sessions. I mentioned to you, safe harbor language is there. All you got to do is cut and paste and fill in the blanks. If you cut and paste and fill in the blanks, then no one can challenge that you have adequately described those closed session items, okay? Prior to your closed session, the board must make a public announcement of the reasons for the closed session. Before you go in, you have to say what are the reasons why you're going in. So practical tip for you, I usually advise that you just have an item on your agenda before closed session. It says, public announcement by board chairman of reasons why we're going to closed session. Just so that you never forget to make that public announcement, right? It's not for any other purpose than that. Also, the public must have an opportunity to comment before you go into a closed session. The frustrating thing is that because the public doesn't know what you're talking about in closed session, oftentimes, they may get up and you may experience 20 or 30 minutes of testimony that has absolutely nothing to do with what you're talking about. They may see an anticipated litigation item and they assume it's about case X when really it has to do with a kid who tripped and fell yesterday, you know, and they have no idea because they don't even know the kid tripped and fell yesterday. But regardless, you have to give them an opportunity to comment before the closed session. It may or may not be relevant to your conversation, but they have the right to comment. After that closed session, the board must make a public report of any action taken, right? Not discussions. You don't have to reveal the content of your discussions because that would defeat the whole purpose, right? the purpose of you being in closed session to talk about negotiating with your labor union or a landlord or an opposing party in litigation is to strategize and get the best deal, right? So we're not gonna have you talk about what your strategy conversation was, but if you took final action, to settle a lawsuit or something like that, that final action would be reportable. Semi-closed meetings are prohibited. This just means you cannot invite your friends and exclude your enemies. Okay? So you don't get to pick and choose who gets to come into closed session. And the other common violation that occurs here, and I regularly kick people out of closed sessions, is sometimes there'll be an item where there's anticipated litigation and I'm there for that reason and the realtor is there to talk about a real estate deal. And I'm like, hey, the realtor can't be here while I'm talking to you about the anticipated litigation. They should be here only for their item in closed session. So you always have those people only be in closed session for their respective item and nothing else, okay? Confidentiality is required. So for all members of the board, anything discussed in closed session must remain in closed session. If you fail to meet that obligation, one of two things can happen to you. Either A, the grand jury can come after you for your breach of closed session confidentiality, or the full board might sue you for damages. And I've had circumstances like that occur over the years, unfortunately, where boards have found themselves debating whether to do that. For example, I had a case where the school was going to make an offer to lease some property, and a board member ran out of the closed session, called his realtor, and had his realtor make an offer to lease the building before the school's offer would arrive the next morning. Okay, that kind of stuff is shady. You don't want to be doing stuff like that. And what that's going to cause is the rest of your board will see that as a breach of your fiduciary duties and a breach of the Brown Act, and they might sue you personally for damages. So watch out for those kinds of things. Similarly, if you ever find yourself in a situation where members of the public or the media are questioning your decision to release an employee or to expel a kid, never ever comment on those kinds of things, because the confidentiality, even if you had good reason to fire that person or to expel that student, if you disclose that to members of the public, you've breached their right to privacy, and they're going to have a claim against you, even if they legitimately did something wrong and you legitimately let them go for a good reason. So for heaven's sakes, don't give them cause to have a claim against the school or against you or against your board. So what if, in spite of all that we've talked about today, there's some violation occurred? What's going to happen, right? So someone can file suit, any random member of the public can file suit against you and can argue that you've breached the Brown Act provisions and ask the judge to declare that your action be null and void. And what that would do is it would force you to essentially start that process over relating to that agenda item, post an agenda, discuss it, and vote again, okay? The judge might also grant injunctive relief to prevent you from violating the act going forward in the future. And finally, the prevailing plaintiff is awarded attorney's fees. And that is the one that really is the kicker, because usually the attorneys who take this on are the folks at the big downtown firms. And so their rates are a heck of a lot higher than mine. So it's painful because you've already paid your own attorney and now you're paying them twice as much on the other side. And it's just excruciating to pull that money out of the classroom. So what do I suggest to avoid that consequence, right? Before they can go down that path, they have to give you a notice and demand a cure from you. They have to demand that you fix it, right? And so if ever you get a notice and demand for cure, what I'm going to tell you is, if you think that there's any chance a judge might perceive that you violated the Brown Act, always better to post the agenda, discuss, and vote again. Always better to do that than to be in a situation where you are hauled into court over something like this, because it's just a waste of taxpayer money. Criminal penalties may apply. As I mentioned, it's a misdemeanor, but only if you intended to deprive the public of information that you knew or had reason to know the public was entitled to. So again, there's an intent element here. So it's not that you can be hauled, into criminal court because you made an innocent mistake. People make mistakes, And that's not what this is about. This is about you intentionally, essentially plotting to keep information away from the public, right? We care about that level of intentionality. And then ongoing violations of the Brown Act can also lead to potential revocation. And in many of the cases where charters have been revoked, Brown Act violations have been among the reasons why a charter was revoked. In only one case that I'm aware of has a charter ever been revoked only for Brown Act violations. But there was one case where that happened up in Butte County several years back. So it can happen, but in that case, the charter had a severe and pervasive set of violations, and despite multiple trainings, despite multiple assurances, despite multiple reminders, they still just couldn't seem to get it all the way together, and the school board revoked. The judge upheld the revocation, saying that was okay. So, so if you get one of these notices and demands, right, I mentioned to you, you want to make sure you respond within 30 days. And most typically, if you think there's been any sort of violation or it's a gray area, you're probably just going to say, hey, we meet once a month anyway. We'll just throw it back on the agenda. We'll make sure we post it right next time. We'll discuss it. We'll vote again, right? You might also get a notice of concern from your authorizer. And if you get one of those, then of course you want to respond and you want to say, hey, we're going to get training, or we're going to fix it this way or that way. And the response will depend on the nature of the allegation and the nature of the facts in each case. So with that, we have come to the end of Brown Act. Are there any other burning questions that my slides did not answer? Question here from Dante.
Charter schools, many of them have established foundations.
Yes.
Does the foundation have to be under the Brown Act?
So that's an interesting question, because there is a sentence in the Brown Act that talks about entities established by a public agency that is subject to the Brown Act sometimes are covered. And so what I would want to do is look at the specifics of the relationship between the two entities, which I haven't done, so I don't want to answer that on the fly, but there is at least a theoretical possibility that the foundation might be covered. And so I'd want to look at the specifics of that before answering them. Other questions? Great.
Thank you very much, Jerry. It's very informative.
Okay, great.
Excellent.
Mr. President, might I propose a 5-minute break?
Yeah,
so we
I
can
was
go
going
ahead?
to take a 5-minute break and we'll reconvene to open session.
Is it cold now? It's cold. Okay, like, it's hot, it's cold, I don't know.